Our boy James over here has some good news, apparently. We made it past the motion to dismiss in the defamation lawsuit in PV versus New York Times. We're going to dispose of them on videotape, and we're going to win. Who's laughing now? Dean Boku? Oh, we've got the lawsuit right here. Let's just dive right. I always love reading these lawsuits. This one's relatively short, 16 pages. 16 pages. Yeah, no, these things can be 100, 120. They can be 400 pages long, so this is pretty good. Let's see here. Here we have the Supreme Court of the State of New York, County of Winchester, PV plaintiff against New York Times Company, Maggie Astor, Tiffany Snow, John Doe, 1 through 5 defendants. Wood J, that's the judge. New York State Court Electronic Filing, NYSCFEF. Document number blank, whatever, were read in connection with defendants in the motion of the New York Times reporters, Maggie Astor, and defendants to dismiss plaintiff complaint pursuant to, I don't know what CPLR is, based on documentary evidence for failure to state cause of action. Arguing mandatory attorney's fees and costs. Anti-SLAPP. Oh, they tried to get anti-SLAPP against the PV. Plaintiff, a nonprofit journalistic organization, brought this action against defendants for publishing 5 purportedly false and defamatory articles in September and October of 2020. The articles reviewed a video report published on September 27, 2020 by PV. The topic of alleged illegal voting practices featuring a Somali American Minneapolis campaign worker named Liban Mohammed. The video also featured an interview with Omar Jamal, a community service officer of the Ramsey County Sheriff Office, and a political consultant of the Minneapolis Somali American community. So the reason I'm slowing down right now is I'm going to be carefully reading all these sentences and censoring them on the fly, because YouTube has a very strict policy when it comes to election-related content. So if I'm not reading the document right, it's partly because of my dyslexia, but also partly because I'm trying to censor this. Jamal stated that there was widespread corruption by Somali politicians who were all part of an extended Somali American clan, including cash payments to elder voters in exchange for things. Allegedly. I don't know if any of this is true. This is what a lawsuit says, you guys. This is all probably made up, right? I disavow anything and everything. Veritas claims that it did not selectively edit or doctor any of the interviews presented in the video. Yo, man. I am back. How's it going, man? I was just taking a little break. My job has been really kicking my butt lately. So, anyways, enough about me. The articles include 3 written by defendant Astor, first on September 29, 2020, titled PV Video Was a, quote, coordinated disinformation campaign, researchers say, which was published by New York Times. On the same day, an abbreviated version titled, researchers say PV video accusing Ilhan Omar of, I'm going to say, instead of voter, we're going to say V, okay? Accusing Ilhan Omar of fraud was a coordinated disinformation campaign published online by New York Times. The last was September 30th, titled PV Releases Misleading Video, part of what experts call a coordinated effort, published in print, New York Times. Oh, published in print? That's pretty bad. Print is, oof. You can't ghost edit print, man. Let me tell you guys something. I have I have these books, okay? They're from 1991. I got like a 30-page volume, and World Book Encyclopedia. That's an atlas. Can't ever change print. So that's pretty interesting right there. Sorry, a little tangent. Anyways, yo, Miss Badger, glad to have you here. Additionally, defendant Sue wrote 2 articles about V. The first on October 25th, titled "Conservative News Site Fuel Fraud Misinformation," was published online by New York Times. On October 26th, a substantial similar version of the first article, titled "False Fraud Stories Are Churning on Conservative News Sites," was published by New York Times. Yo, Propaganda Panda, glad to have you here. That's a great name, by the way. That really rolled off the tongue. According to the complaint, New York Times, Astor, and Sue are driven by resentment and journalistic competitiveness after the New York Times' much-hyped story about President Trump's tax returns were upstaged by V's video report, as well as their own political biases against V's perceived right leanings. So they set out to discredit V's reporting. V asserts 5 counts of defamation, alleging that the defendants published false and defamatory statements, impugning V's journalism with reckless disregard for the falsity of those statements. So, guys, what do you think? Some of you guys may have seen the video already. I saw the video. Releases misleading video. So, is the term misleading slanderous? Technically, you could say New York Times makes misleading headline. Misleading is highly subjective. Video was part of a coordinated disinformation campaign. What does that mean, part of coordinated disinformation? You were part of a coordinated disinformation campaign. Anybody could be part of a disinformation campaign. We are all part of them all the time. If you're talking or hearing about something, these are so broad statements. It's amazing how the news is able to do this type of stuff. They're so creative with their words. They're real geniuses at it. All right, so we are on page 3. It's only 16 pages. This is really short, you guys. Stick with me. And hit the share and like button, by the way. It really helps. In the instant motion, defendants argue that V failed to adequately plead and cannot demonstrate with clear and convincing evidence that there is substantial bias in the law and the fact that defendants acted with actual malice, which is, defamation against public figures. You have to prove actual malice. Now, you don't have to actually get emails where they're saying, we're going to purposely lie about them, If you can demonstrate that they knew it was wrong and they were still doing it anyways, that's acting with malice. Defendants reporting on the video was substantially true and corroborated by other news outlets and fact checkers. Veritas failed to allege a false or defamatory fact. Oh, I said the word. Damn. We'll have to beep that out later. What time is it? 9 minutes in. Okay. V failed to allege a false or defamatory statement of fact. V's extensive repudiation of publishing selectively edited videos makes it libel proof. Its extensive reputation of publishing selectively edited. Wow. I was trying to avoid it. This stream is just gonna tank now, okay? Well, the stream's cursed, but the video is supposed to upload later. Anyways, now based on the foregoing, the motion is decided as follows. Oh, here comes the juicy part. Yes. And he won this, so here we go. Generally, this law provides that upon a motion to dismiss, failure to state a cause of action, the sole criterion is whether the subject's pleading states a cause of action, and if the four corners of the complaint factual allegations are discerned, which taken together manifest an actual action, manifest a cause of, which manifest any cause of action cognizable at law, then the motion will fail. So you have to look at the whole picture. The court must afford the pleading a liberal construction, accept the facts alleged in the proceeding as true. Yep, accept the facts as true. So, New York Times can't say, no, your facts are wrong. No, the facts by the person pleading are taken as true. Accord the plaintiff the benefit of every possible inference and determine only whether the facts as alleged fit within any cognizable legal theory. Here, V's complaint adequately pleaded the 5 causes of action sounding in defamation. Defamation can sound in libel or slander. Libel involves publication, something in writing or pictures, and slander involves statements, something spoken. The elements of cause of action for defamation are A false statement that tends to expose a person to public contempt, hatred, ridicule, aversion, or disgrace. So, ridicule is a thing, right? Ridicule? You're causing ridicule when you say, when they're part of a coordinated efforts. Any other statements here? Maybe if we actually cracked open these articles, we could see some more statements they made. Lost my place. Excuse me. We were on A, so now we're on B. Published without privilege or authorization to a third party. Interesting. So like a secret recording? Amounting to fault as judged by, at minimum, negligence standard. Interesting. Negligence. Negligence means you'd have a duty to know. And D, either causing special harm or constituting defamation per se. So defamation per se is when you are like, the thing you're saying is defamatory. Like if I said X person is, and then certain type of felons that are really badly despised, just saying that is defamation. Saying that person makes misleading stories isn't really defamation. It's kind of my opinion. But saying like a factual bad thing about somebody like that, yeah, it's defamation per se. And then based on the deciding issue of defamation on a motion to dismiss, the second department held that the truth of an absolute defense of a defamation action and the test to determine whether a statement is substantially true is statement is true, is whether the statement as published would have different effect on the mind of a reader that which the pleaded truth would have produced, as statements alleging facts that can be the subject of defamation action. Wow, there's so many quotes here. An expression of pure opinion is not actionable, no matter how vituperative or unreasonable it may be. Oh God, what's this word?
Vituperative.
Vituperative, using or containing harsh, critical, irate language. The question is not whether it is an isolated assertion of fact. Rather, it is necessarily to consider the writing as a whole, including the tone, the apparent purpose, as well as the overall context of the publication, to determine whether the reasonable reader would have believed that the challenged statements were conveying facts about the complainant. Thus, in determining whether the complainant states a cause of action to recover damages for defamation, the dispositive injury is whether a reasonable listener or reader could have concluded that the statements were conveying facts about the plaintiff. There we go. Bam. Defendants claim that reasonable reader would understand that the primary gist of the articles was that the video was deceptive because it failed as promotional materials for the video, and the video itself claimed to show that Rep. Omar's campaign was linked to alleged harvesting scheme that linked Rep. Omar's campaign, and the fraud purportedly depicted in the video is what the article identifies as relying on unidentified sources with sorry, this is a long statement. Sorry, I want to highlight this part right here. The link between Rep. Omar's campaign and the fraud purportedly depicted in the video is what the article identifying as relying on unidentified sources and, quote, with no verifiable evidence, end quote. Yeah, right. They have a video of the guy whose face is on camera. We know his name, and they're saying these are unidentified sources, and there's no verifiable evidence, which led to the description of the video as deceptive. Not all aspects of the video. The gist of the statements is the allegation about Rep. Omar's campaign connection to the fraud are insufficiently supported, which is what numerous, quote, independent reputable news sources and fact checkers concluded. The defendants also appear to argue that tweets or other marketing by Veritas and third parties to draw viewers to the video by V somehow made the concept of the video deceptive. In response, V contends that New York Times' own ethical policies, which New York Times publishes on their website, prohibits news reporters from injecting their subjectivity opinions into news stories published by New York Times. Thus, a reasonable reader would expect a news reporter's statements to be assertions of fact and not opinion. Oh, well, okay. Right? It's right on their website, yeah. Or has the gray lady's reputation absolutely died now? I don't care either way. However, defendants rely on recent federal cases where court rejected arguments that the inclusion of article in the news section rather than in the opinion section is dispositive of whether statements contained in the article should be considered as fact or opinion. Wow. So it doesn't even matter if it's in the opinion or fact in the news section anymore. It's all the same thing. That's so nice. When this ruling came out? 2020. Psst. Guys, the absolute state of the news. Friggin' wrecked by this judge. I don't think he wants it. I think he's just he's saying this is a descriptive. He's making an observation. He's saying the way the news is today, anything in the news section is pretty much opinion. So whether a statement constitutes a fact or opinion is a question of law for the court to decide. Okay, that's interesting. Considering the following three factors. I, whether the statement is an issue, the issue has a precise, readily understood meaning. Okay. All right. Whether the statement is capable of being proven true or false. Whether, okay, so that's like fact-checking someone's opinion or their state of, their thought processes is hard. People familiar with Trump's thinking. Really? People know what Trump is thinking? Did Trump say what he was thinking? Or did he just say some words and they tried to guess what he was? Yes, exactly. Anyways, 3. Whether the full context of the communication in which the statement appears or the broader social context of the surrounding circumstances are such as to signal readers that what is being read is likely an opinion, not fact. Okay, so if you have like a giant opinion on the top of your section, like other stuff like The Onion or, Clickhole, this court reviews the articles involved considering the full text of the article in which the purported defamatory statements were made. Actionable assertions of fact are tightly intertwined with what defendants now characterize as opinion. Exactly. when you're trying to say that someone's unidentifiable, he is identified. They identify him in the video. You're trying to say like, well, no, in the video, you can only see his face. You can't see a badge. And so he is like, he's an unidentified person. See, technically we're true. And so it's like, get out of here. Get out of here with those technicalities. In part, defendants argue that their statements describing V's video as deceptive, false, or without evidence were mere opinion, incapable of being judged as true or false. However, if a writer injects an opinion in a news article and will seek claim of legal protection as opinion, it stands to reason that the article should have obligation to alert the reader, including a court that may have to determine whether it is fact or opinion, that it is an opinion. So yeah, the judge is saying, hey, everything you're saying, it's like when a cop pulls you, everything you say can and will be used against you. Well, you didn't want to say this was an opinion, and you lied by omission, basically. So naughty, naughty. The articles that are subject to this action called the video deceptive, but the dictionary definition of disinformation and deceptive provided by the defendant's counsel certainly applies to Astor's and Sue's failure to note that they injected their opinions in the news articles as they now claim. Ooh. Likewise, defendants now appear to assert that the promotion of the video where the deception was. So they had to do affidavits. Interesting. We'll have to get those affidavits. But there's a difference between viewing a disappointing fight of the century and reporting it that it was not worth the pay-per-view fee or did not live up to the hype, and reporting to the public that the pay-per-view knowingly marketing the fight that it was fixed. So yeah, there's a difference between, one is like you're saying it's fixed. Geez, you're saying some nefarious action there. You're saying it's like they lied about the audience, that it wasn't. That's a statement of fact, right? And this is an opinion that it wasn't worth the money. Yeah, wasn't a hype. Yeah. Plaintiff is entitled to try to establish whether New York Times writers were purposely or recklessly inaccurate, or whether they were incapable, sloppy, or something less. Oof. Something less. New York Times is something less. For instance, in defendant's Astor's article dated September 29th, she spends the majority of the article merely describing the video and speaks to conclusions of researchers of Stanford University and University of Washington and others. There, Astor obviously reports on these findings of these groups. Throughout the article, they are purportedly cited. However, the sources of the following statements is unclear, or if it is fact or opinion that, quote, Mr. K and PV have a long history of releasing manipulated or otherwise selectively edited footage purportedly to show illegal conduct by political groups. Is that an opinion, or is that you're having an expert give an opinion? What's the point of an expert? Expert's supposed to give facts. It's an expert opinion. Is that a fact then? In the second video Astor article, as dated September 9th, there are citations to researchers. But this one statement is unclear whether its source is Astor or it's information told by her by the researchers. PV had hyped the video on social media for several days before its publishing it. Its post amplified other prominent conservative accounts. Mr. K, OK's, teased what he said the evidence of fraud and urged people to sign up at a website you can see right here to receive the supposed evidence when it came out. Parentheses. None of the material in the video actually showed proof of fraud. The third article is a repetition of the other two articles. Next subject articles by Sue, October 25th and 26th, contain questionable language, whether fact or opinion coverage. I just want to say, shout out to these New York Times reporters for blurring fact and opinion. Is that one of the reasons why we live in like a clown-like world? Nobody can tell what's going on anymore. Isn't that what Mr. Jones has been doing for a while? You know, first name Alex. Some people say he's grifting. Some people say he's just trying to, you know, do a fudge a news show like I am. I don't know what people's motives are. And he's trying to make an entertaining show, maybe. Whatever. But right here, maybe the New York Times is trying to make an entertaining article, right? You always got to be putting it on their shoe, on the other foot. So which side's going on here? With their facts and opinion, Tucker Carlson, you know, is that fact or opinion going on there? He's kind of mixed the two together. That's the thing, though. It's because you want to hate. You want to slander the person, but you legally can't. So, but really what happens is you just want everybody to hate these people. Like New York Times wants everybody to hate PV because, you know, they're discrediting certain political parties. So they just but they can't like slander them outright. So they're trying to like just say like take their opinion anyways. This is really, really great stuff. Radically moderate, good analysis, man. This is just fucking groundbreaking content here. All right, let's continue. Well, Mr. Warface, Fist, you calling him that is like, remember when Elon Musk got in trouble for saying that someone was a pedo dude on Twitter? It's almost, he didn't get in trouble because it's an opinion statement. They say that someone's like a pedo. Go out and say that they're doing things of kids, crimes against kids, well then you're doing something else, okay? Then if you want to fucking dance on the fire, War Fist, you need to start saying, Alan did this on this date with this kid and did this crime. And you start trying to make that go out, and you see how quickly he shuts you down. I'm just saying, you calling him a pedo on Twitter versus what I just described, you go in the New York Times and you say that crap about him, you see what happens. Anyways, partly is your reputation. Nobody like knows you. You're not the New York Times. That's why part of this is going on. New York Times information said that they're supposed to be putting out fact. I don't know what you put out. So, more of the article. In a similar cycle, Fox News host Sean Hannity and other conservative publications magnified the reach of a deceptive video released last month by PV, a group ran by conservative activist JOK. The video claimed, without named sources or verifiable evidence, that the campaign for Representative Illinois, a Minnesota Democrat, was collecting ballots in ways I can't even describe. Wow. without verifiable evidence. There's a self-admission of a dude saying, yeah, hey, TikTok, you won't believe what I'm doing right now for money. I'm making all this money collecting all these things right here. But okay. Stating the video is deceptive or stating without verifiable evidence is a factual way a news article certainly presents the statements as fact, not opinion. A deceptive video without verifiable evidence. Those are statements of fact, the way they're described right there. Okay, not opinion. Further, the Astor and Sue articles could be viewed as exposing V to ridicule or harm to its reputation as a media source because the reader may read the news articles expecting facts, not opinion, and conclude that Veritas is a partisan zealot group deceptively editing the video and presenting it as news. Yeah, well, that's part of what New York Times actually thinks is going on, though. New York Times thinks they're deceptively editing these videos by just showing them at all. You even don't believe your lying eyes. Literally. Upon review of the total context and tone of the stories, which clearly disparage V and the video, the court concludes that a reasonable reader could very well believe that the challenge statements were conveying facts about Veritas. Boom. The articles certainly could be viewed as being purposely designed to appear that defendants are imparting facts and evidence that V's videos were deceptive and that V is merely a right-wing political group. Alternatively, defendants argue that the term, even if the term deceptive could be given objective meaning as factual statement, defendants demonstrated that the video is deceptive and that the challenge statement is substantially true. Listen, Judge, it's an opinion, and even if it's not an opinion, it's true. As many news outlets and fact checkers independently confirmed. You mean also partook in the defamation? That's what you're saying right there, because the judge is saying that this is defamation. So this independent confirmation doesn't mean anything. The fact that 9 out of 10 dentists recommend Radically Moderate's new toothpaste doesn't mean it's a good toothpaste. The same thing of 99 climate scientists. The truth is an absolute defense. Attached to defendants' moving papers are over 52 sources describing V's poor reputation for publishing deceptively edited and misleading videos. According to defendants, those sources are not just some criticism from misleading or left-wing media, but rather they come from a variety of reputable sources, including Fox, Cato, LA Times, Newsweek, WAPO, The Blaze. Far from being some criticism, these sources resoundingly describe PV as partisan zealots with a history of distorting facts or context and running cons. If you do undercover journalism, you're running a con. Hey man, well that's some way you got to get the scoop. Misleadingly edited videos and being, quote, known for its deceptively edited videos, end quote. See, whatever. While this is a lengthy media list, polling does not truth nor speak to evidence. Boom! Fucking mic drop. What did I tell you? 9 out of 10 dentists are fucking wrong. And defendants have not met their burden to prove that the reporting by Veritas in the video is deceptive. Oh, you know what else? In the impeachment, the second one against Donald Trump, they cited the media like 60 times or more than that. You just can't just keep citing the media all the time. It doesn't matter. It's polling. It's bandwagon. Anyways, let's continue. And the defendants have not met their burden to prove that the reporting by the Veritas, by the reporting by V in the video is deceptive. Defendants' papers do not conclusively establish that the subject causes of action do not exist, and the court's review of the complaint finds that V's adequately pleaded 5 causes of action set forth in the complaint. Oh, crap. Oh, yeah, that's good. Quote, whether a plaintiff can ultimately establish its allegation is not part of the calculus in determining a motion to dismiss, end quote. Likewise, cited by the defendants, permits to use the documentary evidence in support of a motion to dismiss defamation claims where the documentary evidence utterly refutes plaintiff's factual allegations, conclusively establishing a defense as a matter of law. I don't understand what that means. Let's try to understand what that means. Defendants, so New York Times. So this action cited by the defendants permits the use of documentary evidence in support of a motion to dismiss. Yeah, we're trying to dismiss Mr. V's, where the documentary evidence utterly refutes his factual allegations. So utterly refutes. So the refutation would have to be something proving that New York Times did not defame PV. And so you'd have to have some like hard-hitting evidence that, not just people's opinions. So here the court finds that documentary evidence submitted by defendants fails to refute plaintiff's factual allegations. Notably, V's documented in his complaint metadata and screenshots that demonstrate the unlikelihood that Ms. Astor read and digested the EIP report blog post reviewed news reports on Minnesota ballot issues, and viewed the video online, obtained comment from Alex Stamos, and wrote her article, submitted it to her editors, and posted it online, all within 63 minutes. So that's what they're saying here. V is saying, when you posted it online, it was 63 minutes after we released our drop of our big video. You released your article. That's because you had your article written ahead of time. Because there was malice there. Because if when we released our video and you wanted to fact check it, you would actually have to call up these people, and that'd probably take a day or so. Not 63 minutes. Next, defendants argue that V is libel proof. What is libel proof? This is a question of law for the court to decide. All right. The libel-proof plaintiff doctrine bars relief in defamation action as a matter of law to plaintiffs whose reputation with respect to a specific subject may be so badly tarnished he cannot be further injured by allegedly false statements about that. So it's like Hitler. You can't say anything. You can slander him all you want. Because he's already like the worst person in history. Or like the devil, I guess. Defendants failed to demonstrate that V is a classic libel-proof plaintiff whose reputation is so bad it cannot be defamed. That other media sources have criticized this. They got a good judge here. That's what happened. They lucked out. This judge is, because all of these things right here are all dependent upon the judge. If the judge had a bad lunch that day, could have just ruled it. These are actually kind of long. But wow. Defendants failed to demonstrate that V is a classic laboratory representation so bad it can be defamed. That other media sources have criticized V, or that V may have suffered blows to his reputation without more, fails to meet the standard. Yeah. Accordingly, defendant's motion pursuant, I don't know what that is denied. Let's just look at that up. Can we Google this? Motion to dismiss. Okay, so the motion to dismiss is denied. Notwithstanding the foregoing, the analysis does not stop here. Defendants asked the court to apply the recent amended anti-SLAPP law comprised of various civil rights law. The strategic lawsuit against public participation, SLAPP, laws are enacted originally to broaden protections of citizens facing litigation arising from their public petition and participation. So, if I want to do some free speech stuff and people start suing me wrongly, well, the anti-SLAPP is for that. In fact, this version of the law existed in November 2, 2020, commencement of the day of the action. The purpose of the enactment of the anti-SLAPP law was I know I got that law basically wrong here. Libel proof protects the speaker or the publisher from defamation. The purpose of the enactment of the anti-SLAPP law, it was to stop meritless nuisance litigation by well-funded developers against average citizens who participated in public discourse against developers or their projects. Okay. I can't afford to be sued, so don't come after me. 8 days after the commencement of this action, November 10th, the anti-SLAPP law was amended. Definition of an action involving public participation and petition was expanded to include any communication in place of open to the public and a public forum, any lawful conduct in furtherance of the existence of constitutional right of free speech in connection of an issue of public matter. All right. So a news article, basically, right? The next provision of the anti-SLAPP law falls under a motion to dismiss is based on in which the moving party has demonstrated that the action involves public petition participation as defined in blank. Unless the party responding to the motion demonstrates that the cause of action has substantial bias in law or is supported by substantial argument for extension, modifying, or reversal of existing law, the court shall grant preference in hearing such motion. So you have to actually prove them wrong, basically. Civil rights law. God, I'm so bad at law, you guys. Why are you even watching me? Civil rights law goes one step further by creating an affirmative cause of action to recover damages from plaintiffs, including attorney's fees and other damages from plaintiffs in specific circumstances, if it can be shown that applicant brought the action without substantial basis in fact or law. So this is what's happening here. If PV here suing New York Times loses their they weren't actually defamed by New York Times can basically countersue anti-SLAPP and get some money back from PV here. In these recent amendments by the legislature have turned the original purpose of the anti-SLAPP law upside down. Here, one of the largest newspapers in the world since Abraham Lincoln was engaged in the private practice of law is claiming protections from an upstart competitor armed with a cell phone and a website. Mic drop by the judge again. Yeah, anti-SLAPP was supposed to help the small guy, but that's the way the law works. The law applies to everybody, even the big companies. Big companies using anti-SLAPP law now. Not only does this amended anti-SLAPP law grant protection to the Goliath against David, but 16 years after the SLAPP law was enacted, a newspaper had never qualified for SLAPP protections for its written articles. Despite this dizzyingly turnabout created by the legislature, the court agrees that this action meets the amended anti-SLAPP standard as it arises from New York Times reporting on an issue of public interest, allegations of systemic fraud, and potential disinformation about such fraud. Accordingly, since under blank, defendants have moved to dismiss this action under this anti-SLAPP law, and it demonstrated this action entitles them to additional protections. This motion, this law, whatever, section G, shifts the standard of burden for the motion to dismiss from defendants to V to, quote, demonstrate that the cause of action has substantial basis in fact and law. So, V can't just kind of allege stuff. They actually have to back up their word. All right. In opposition, V argues civil rights law should not be given retroactive effect here, in that the text of November 10th, 2020 Act, along with blank, nowhere states the amended shall apply retroactively, but states only shall take effect immediately. Retroactive operation is not favored by the courts, and statutes will not be given such construction unless language expressly or necessarily implications require it. However, remedial legislation shall be given retroactive effect in order to effectuate its beneficial purpose. Other factors pertinent here to consider whether the amendment conveyed a sense of urgency and whether the amendment itself reaffirms a legislative judgment about what law in question should be. Oh my God, I'm losing myself here. If you guys aren't following it, neither am I. We're on 11/016. To date, 3 federal courts have ruled that the amended anti-SLAPP law should be given retroactive effect. Okay. In one case, where New York Times was the defendant, the Southern District ruled that it is clear that 76A is a remedial statute that should be given retroactive effect. The legislature conveyed a sense of urgency by directing the amendment to take effect immediately. Likewise, Eastern District found the anti-SLAPP amendments are remedial. Okay. They said the same thing. While the federal decisions are not binding on this court, here V has not sufficiently raised any harsh impact that would preclude the applicability of the anti-SLAPP statute, and thus the court will apply the anti-SLAPP statute retroactively. Eventually, to prevail at trial, V will have a high burden to show actual malice with clear and convincing evidence. The burden of proving actual malice requires the plaintiff to demonstrate with clear and convincing evidence that the defendant realized his statements were false, or that he subjectively entertained serious doubt as to the truth of his statement. Actual malice is a high bar, for mere allegations about improper political or personal biases do not establish actual malice without additional facts who suggest speaker acted pursuant to that bias. You need additional facts, I guess, right? Well, maybe discovery will show that. Veritas argues that not only does the complainant argue the defendant had knowledge that the falsity of the defamatory statements at the time of the publication, but pleads that detailed facts showing the presence of literally every hallmark of actual malice recognized by law, including setting out with a preconceived narrative, being motivated by ill will and bias, failing to contact obvious source of information, relying on biased or non-credible sources, violating journalistic standards, and refusing to retract. Veritas alleges that this has far exceeded that standard by pleading overwhelming circumstantial evidence of actual malice, including that Astor and Sue knew their claims about the video report were false because they had themselves reviewed the video report. Veritas alleges defendants knew Omar Jamal, the man they allege in the video was the primary source in the video, has long been considered a credible, on-the-record source by the New York Times itself. Defendants were motivated by bias and will because they believed the video report was upstaging their story about Trump's tax returns, and because Democrats all politically disagree what they perceive as V's rightward leanings. Sue later, October 20, Sue's later stories were motivated by vindictiveness and desire to harm V's for demanding a correction of Astor's story. The Times and its reporters set out with a preconceived storyline that the video report was manipulated and deceptive, and they ignored any evidence that contradicted that prejudged narrative. Astor and Sue failed to conduct a reasonable investigation and had intentionally failed to reach out to obvious sources they knew would contradict the claims they planned to publish, including Veritas and the name sources in the video. Hold on, guys. Let me do gassed right now, literally. Okay, sorry about that. By intentionally declining to seek comment from Veritas pre-publication, both Astor and Sue blatantly violated New York Times' own published policies and ethical guidelines requiring reporters to seek comment from story subjects. While defendants attempt to argue that Astor did not act with actual malice because she relied on a blog post by a group called the Election Integrity Partnership, V had alleged and demonstrated that through website metadata that the blog post and Astor's story were part of a joint coordinated effort between the EIP and the New York Times to smear V. V further alleges that Astor knew that the EIP blog post authors were heavily biased, as one principal author had been previously a subject of a V story exposing wrongdoing on his part of his employment at Facebook. I thought I turned this off. Why is this not turning off? Defendants claim that Veritas fails to consider 6 stories. I said the word again at 53 minutes. Fails to claim that V fails to consider 6 stories that precede the Astor articles and attack the video as deceptive and providing insufficient support for its claims connecting Reps Omar's campaign to alleged pervasive fraud scheme. It also fails to account for the fact that only 2 of the 8 articles published after Astor's article make any reference to them. Defendants argue that 14 sources concurred the video was deceptive, and that unsupported claims purporting the link to Congresswoman Omar's campaign and a legal fraud scheme, and numerous sources recounted V's widespread reputation for deceptive editing, giving defendants every reason to believe the video was deceptive. The court can take judicial note of those sources, not for the truth of the matter asserted by their statements, but to determine New York Times did not act with reckless disregard for the truth. So, defendants argue, hey, we're sticking by the everyone else was doing it excuse because that's good enough. 9 out of 10 dentists say you're a racist, so it's good enough. Defendants also point out that the video was released video was released, they submitted reports of alleged independent fact checkers, news organizations, and reputable academics from the defendant's point of view, as being, among other things, misleading, unfounded, and part of a disinformation campaign and false, and that within the days of the video being released, Omar Jamal, a key source in the video, went on Somali American TV and reportedly backtracked on the allegations. Another man featured in the video, Libin Osman, told investigators that Fox News that he was offered $10,000. He was offered a $10,000 bribe by Omar Jamal to be paid by PV to falsely say he was collecting ballots for Rep. Omar. He told investigators of Fox News he was offered a $10K bribe by Omar Jamal, paid by PV. PV gave Omar Jamal 10 grand to give to this other dude to say he's collecting shit. Is that what's going on here? What's going on here? PV's making their own news. Turning it to submissions of the parties, the court first must disagree with the defendants that the clear and convincing standard applies to this motion. This action does not impose a clear and convincing standard that the parties opposing the motion must demonstrate that the cause of action has substantial basis in law. Notably, the antistep contains the same substantial basis in law as the language. In deciding the recent motion, the Second Department held that this standard was below the standard for summary judgment, and the plaintiff must adduce allegations evidence by demonstrating an existence of triable issues of fact. The court finds that the documentary proof and facts alleged by V are sufficient to meet its burden. The facts submitted by V could indicate more. The facts submitted by V could indicate more than standard garden variety media bias, support a plausible inference of actual malice. There is a substantial bias in the law to proceed that permit the plaintiff to conduct discovery and then attempt to meet its higher standard of proving liability through clear and convincing evidence of malice. Facts submitted by V could indicate more than standard garden variety media bias. Okay, so they're saying what V is showing here is something else going on here. There is substantial basis in law to proceed to permit PV to conduct discovery and then attempt to meet its higher standard of proving liability through clear and convincing evidence of malice. So go find that malice. Malice focuses on defendant's state of mind in relation to the truth or falsity of published information. If we can find emails saying, hey, we need the EIP to make up some article right now because the P just dropped something. Yeah, hurry. When's it going to be done? It'll be done in 10 minutes. All right. It's dropped. Thanks. Bye. That'd be pretty amazing. Here, there is substantial basis in law and fact that defendants acted with actual malice, that is, the knowledge of the statements in the articles were false or made of reckless disregard of whether they were false or not. V alleged actual malice by providing facts sufficient to defendants' alleged disregard for truthfulness of its statements. Accordingly, at this very early stage of litigation, V's submissions were sufficient to withstand defendants' motions. Further proceedings are necessary to resolve issues raised. In light of court's rulings herein, Plaintiff's V's motion for limited discovery in relation to the present motion is deemed academic and moot. Accordingly, based on the stated reasons, it is hereby ordered that the motion by the defendants for the order pursuant to anti-SLAPP dismissing complainant and award attorney fees on the defendant's counterclaim is denied, and their application for release under New York anti-SLAPP statute is also denied. It is further ordered that any future submissions by counsel shall adhere to the uniform court rule. What is this rule? What's going on here? Why is that? Did somebody break a rule? Uh, 202.8b. 202. Special procedure for unassigned causes. If a case has not been assigned to a judge, a motion shall be made returnable before the court, and a copy of the moving papers together with a request for judicial intervention shall be filed with the court with proof of service upon all parties where required by section and this part. Make sure you send your papers to everybody else with proof of that. Ordered that the parties shall appear at a compliance pact at date and time later designated. It is so ordered by the court. There you go. Project PV winning a court case early. Well, I'm not gonna say he's winning his court case. He's looking good, I guess. We'll see what happens in Discovery. I'm rooting for him. Wish he could take down the New York Times. In my opinion, they're acting with malice. But what can we do at this point? If you guys like this type of content, like, share, subscribe with friends.